Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about hearsay and identification. Cases that should have gone to the Supreme Court of Canada, but didn't. Bitipu Mufuta was charged with sexual assault. This was a historic sexual assault alleged to have been committed by him on a student that he was tutoring years and years before the matter came to court. Ultimately at trial, the issue came down to one of identification. Identification was not able to be made in court, but the Crown relied on identification of Mr. Mufuta that was made outside court as evidence to support that the person before the court and the person facing the charges was indeed the person who had committed the sexual assault. The question then became whether that out-of-court identification was admissible as identification proper or needed to be addressed on the basis of the hearsay evidence test. Out-of-court statements admissible for the truth of their contents are only admissible as a principled exception to the ordinary rule that they aren't admissible for the truth of their contents. The identification was ultimately admitted and Mr. Mufuta was convicted. He appealed his conviction. The appeal was dismissed, and he sought leave to the Supreme Court of Canada. This is a very interesting case because in many cases of historical sexual assault, the issue of the identification of the accused becomes a central issue at trial. And because time has passed, it may not always be easy for the survivors of that sexual assault to point out the person sitting in the courtroom as the person who perpetrated the assault. This is particularly so where the relationship is a relationship that has ended, like a tutor and a child, as opposed to a family member who you see for years throughout your daily life. In those circumstances, there becomes a need to balance the competing interests of the court getting at the truth of the matter, as well as protecting the rights of the accused to not be improperly identified on the basis of frail evidence that can't be tested. This is the reason why out-of-court statements are not ordinarily admissible for the truth of their contents. There's an absence of a reasonable opportunity to test them, both through cross-examination as well as through assessing the perception, memory, narration, and sincerity of the person making the out-of-court statement. In this case, the Supreme Court of Canada had the opportunity to clarify how identity specifically relates to the hearsay rule in cases involving historic allegations of sexual assault perpetrated by strangers or by people who are partially known at that time. In these circumstances, the Supreme Court of Canada could have made the playing field more fair for survivors of sexual assault as well as for people who are accused of these heinous crimes, so that these trials can proceed in a fashion that doesn't drag out the litigation and that doesn't make the process more traumatizing for all parties involved. Unfortunately, the Supreme Court of Canada missed an opportunity to add an interesting and important layer to the assessment of the hearsay rule when it comes to out-of-court identification, and this will have to proceed on another day. The Supreme Court of Canada had an opportunity here to clarify how the hearsay rule could impact issues with respect to identification so that in the future, people who are going through these types of trials, whether as the accused or whether as the witness, don't have to relive that experience of the out-of-court identification through cross-examination and through testimony, or so that we know what type of evidence needs to be adduced for that to be admissible. Unfortunately, the Supreme Court of Canada missed that opportunity, and we'll have to wait for another day for the Supreme Court of Canada to finally decide the issue and create a clear and cogent series of tests when it comes to out-of-court identification and the application of the hearsay rule. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, share with your friends, and tune in next week for another exciting episode.